No one lays down the law like Car and Key. This is the Law Report on SAFM.
And a very good evening to you from tonight's Law Report program. Well, as you know, once a month here on the Law Report, we run a legal clinic trying to answer a range of questions on a number of different topics. And tonight, it's again time to open the lines for you to ask that particular legal question that doesn't quite fit into the other topics we discuss here on the Law Report. So basically tonight, we will not be doing property law or labour law. Those have their specific programs. So anything other than property law and labour law. And I'm joined once again this evening by attorney Nicoline Skuman-Lowe. She's a director of Skuman Law Inc., Attorneys, Conveyancers and Notaries Public. Nicoline, good evening. Welcome back to the show. And it's our last one for the year.
Goodness, can you believe it? Thanks for having me.
It's actually got this year's gone by so fast. If you have any questions for us, you can call us now on 0892 10 2010. 0892 10 2010.
Are you a farmer or community member in South Africa? The Department of Agriculture, Forestry and Fisheries seeks to help you in controlling a disastrous pest from Asia called the invader fruit fly. This fruit fly is new in South Africa, and if it is not properly managed, it can lead to drastic yield loss, food insecurity, loss of export markets, and may result in job losses. You can start by removing fallen or rotten fruit and vegetables in your garden or farm. Bury them in a pit or place them in a closed refuse bag and expose it to the sun. This reduces pest populations. Apply appropriate chemicals for fruit fly control. Apply for a removal permit to move fruit from affected areas to non-affected areas. Do not remove the fruit fly yellow trapping buckets placed on trees in your vicinity. International travelers are advised to abide by our country's import requirements for agricultural products. For further information, call the department on 012-319-6295 or visit daff.gov.za.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
And as I mentioned earlier, it's our law clinic tonight. So any questions you have, but we're not doing questions on labour law or property law. Anything other than that. And of course, Nicoline's favourite topic, wills and estates. So if you have any questions on those, she loves those. Right, Nicoline, we've got some emails here and some letters and things from listeners, so we can get stuck straight into those.
Sure.
The first one is from a listener. He actually, it's quite a long story. So I'll try and condense it. Basically, him and his wife, the wife had decided that she'd wanted a divorce and had threatened the divorce, and then decided no, it was fine. They weren't going to get divorced, and the whole thought and everything was dismissed. They weren't going to do this. Then she said she was going off to visit her daughter in Canada, obviously from a previous relationship. She left and went off. She was going for 3 months. While she is now away, currently still away, before they left, as I said, a very complicated story. Before she left, they had been living in a house, which they then decided to sell, which they did. They married in community of property. They then bought another house with the proceeds of that house, of the first house, and took out a small bond as a couple married in community of property. There was communication between the two of them while she's been in Canada. He then, a few months after she'd gone, went off to the old house to go and check if there was any mail that had perhaps been delivered there, only to find a hand-delivered envelope with one of those stickers that you can actually buy at C&A, those little gold stickers that says confidential for Throlik on the front, stuck on a hand-delivered envelope. And inside, he was shocked to find final orders of divorce. It says that it was done on the 22nd of April. The papers are stamped the 1st of June. And the envelope has a handwritten date of the 23rd of September written on it. He only moved out of that house at the end of September, and this had never been there before he moved. Sorry, so he doesn't know where this came from or who dropped it in his postbox or anything. And I think it was actually, he didn't even know he was supposedly divorced.
Oh, goodness.
And basically, what the strange part was that if this is true, this date on this final order of divorce being the 22nd of April, they bought the house in August, and they bought it as a married couple. She said nothing about, we divorced, actually. Didn't mention that. Applied for a passport to go over to Canada as a married woman. Didn't mention she was divorced. There was no mention of the divorce at any stage. The first he knew about it was when he found this hand-delivered. Surely the sheriff or somebody has to at least tell you that you're getting divorced.
Well, of course, papers need to be served on you.
Yes, well, he wasn't.
Even in the case where the divorce is fairly amicable between the parties. So in rare instances, the parties actually do come to some form of an arrangement, which essentially they then have made an order of court. And it's well, for lack of a better phrase, it's less messy, it's less traumatic for the parties concerned. So, but even in that situation where things are fairly amicable, and there's absolute clarity as to how this will proceed, and it's done by agreement, even in that case, you need to be served with court papers. And if you are not served, because it's a divorce action, you need to be served in person. So if he's never received notification of this, bearing in mind that some months ago there has been some stories in the media regarding fraudulent divorce orders being issued, in this particular story that I am referring to, it wasn't any courts in the Cape Town area, but it involved courts in the Gauteng area. So it would, I think, be worth for the listener to approach the court to uplift the case number or the case file under the case number, and to see if there are actually any paperwork, or if there are any papers within the court file, to give some indication as to whether or not this is at all legitimate. But of course, even if it's, let's take the first option, that it's not legitimate, that it's a fraudulent document for whatever purpose, hand delivered. I mean, it is strange, to say the very least.
And just left there when whoever it was would have known he wasn't there anymore.
Then, of course, it has a fundamental effect on that sale and acquisition of the property. It has a fundamental effect in terms of the bank. And, of course, knowledge and non-disclosure on the party who may have purportedly had knowledge. Now, you need to be served with the papers in person before you actually get your day in court in regards to a divorce action. And it's not like many other types of service where they can affix it or so on. It needs to be done in person. And once that has been done, you get your day in court, or you choose not to attend. If you choose not to attend, then it becomes uncontested or unopposed, and essentially you then the matter proceeds. But someone, in most cases, still needs to be present on the day. So they need to unravel exactly from a court record perspective what happened or what didn't. And it could be useful to take this document with to the courthouse and to ask the registrar if this is
because there is a
authentic.
person's name on the stamp here. There's a Ms. I won't say the name out here, but there's a actual person's name on that. She says she's a regional court in Wynberg assistant registrar, and there's a name on there.
There is a name on there, and in this particular piece I was referring to earlier, that has made headlines in the media, it was actually found that some of these stamps are being forged, and unsuspecting people are being served with divorce papers in final orders of divorce
Like
that
this.
is actually fraudulently created, and it looks very genuine to the naked eye, and there are people that are actually making a lot of money out of this fraudulently. So if the dates do sound, it seems
But
very
if
unlikely.
you look at the immovable property that they talk about in this final order of divorce, the property that they're referring to was the original house before it was sold.
Yes.
But then she, with her knowledge, they sold the house, and with her knowledge and her signature as married in community property, bought another house.
Yes, and that'll have a
And this all
fundamental
happened.
effect.
This apparently she was divorced in April, but
Yes.
yet they bought the house in August.
If this is genuine, that's a massive problem that will need to be addressed with the bank as a matter of urgency. So first step is to actually uplift this court file to see if there is such a court file and whether it is it does relate to this matter, and to ascertain whether this is a
So if there is,
authentic document.
if this is actually a real file, the whole thing is weird that he was never served with papers.
Then, of course, he can obviously apply to court to rescind or in other words, cancel the order that was taken. And I would then, if this is the case, and if there is any indication that the presumable ex-spouse didn't
what
know
we're not
about
sure now,
this,
yeah.
Then, of course, I would take further action against her, possibly on a criminal basis.
He
as
did
well.
actually talk to her via Skype, I gather, while she's still in Canada. And once he brought this up, once he found this thing, when it was found in a letterbox, she admitted it, that yes, she had filed for divorce, but she'd never said anything. And what I'm saying is that she did all this other stuff supposedly knowing that this had happened,
Well,
and
if-
yet
if-
to purported herself to be still being married in community of property.
That's a massive problem, and as I say, you will then have to act against her. So, first step is to uplift the file, make sure this is authentic. You need to know exactly what happened. One can't go on he said, she said, and
Sure.
we think so.
But there
and
are
so-
mistakes in here. I mean, they were on. I not even being of any legal
Yes.
education, spotted the paragraph 2 in paragraph 1 in spousal maintenance, where it actually talks about the plaintiff shall actually receive maintenance and it will stop on his death or remarriage. It should be hers, surely, if this is her serving these papers.
Fair enough.
So, I mean, that is already a mistake. I mean, they wouldn't make that sort of mistake, surely, on a final order of divorce.
These things do happen.
Oh, do they?
Sometimes they do happen. So, and it's obviously fairly. It could only be a typographical error, but nonetheless, it needs to be formally corrected. And if there is such a file, if this is an authentic document, none of the fraudulent actions I was talking about earlier, then it's very important that an open conversation be had with the bank, and I would recommend strongly that this is done with the assistance of an attorney. So, listener needs to get some legal representation.
This
uplift
is
the
a
file.
criminal case then, because, I mean, that's fraud.
Yes, of course. That's exactly what I'm saying. So he needs to investigate the full factual basis of
Whether
the
this
situation.
is real, first of all.
Whether this is real, if there's any indication that the ex-spouse, presumable ex-spouse, knew about this. I know she sort of admitted it in a Skype conversation, but rather get, if there is more evidence, rather obtain the evidence and keep it. It would strengthen any further actions that need to take place from this point forward. And sooner rather than later have a conversation with the banker, but once legal advice has been
So
obtained.
don't do anything without what should he go and try and get that file initially?
Yes.
Okay.
First step, get the file, see what's in the file, see if there's any signatures of the now purported ex-spouse on any of the documents, and then take all of that with all the factual background, see an attorney, and take the matter forward urgently.
Because he could end up losing his house.
Yes. And of course, if, from the bank's perspective, we need to see this. Now, they've done a risk assessment and a credit assessment on the fact that two incomes, two persons.
No, there was only one income, though.
Oh, okay.
There was only one income.
Married in community of property will be paying for this. So if any person defaults, then they've essentially have a bigger pool to look at for repayment. Now, quite frankly, presumably he's he's
been left with it, and she's left the country.
He's been left with it, and he's obviously paying for the bond amount, but it's conveniently registered also in her name, which would complicate things for him personally going forward. So this is not something he can just take on face value, and this is a bit of a hairy situation that I would recommend he
did
seeks
mention
advice
that
on.
she had in there, she says that he can have all the movable property. Fair enough in that thing. But then she has requested that he actually leave his portion of the house to her in the case of his death, that she gets the whole house. And I did actually reply to him and say that I would actually reconsider that, because heaven forbid something happened to him and he was remarried, just for argument's sake. His new wife wouldn't be too charmed if suddenly she got booted out of the house by the ex-wife who now owned the whole house. That wouldn't actually work.
No, definitely, and it's also hard to enforce a provision within a will. But hey, let's keep the matters as
separate. Yeah.
For a minute. It's something that he needs to address on an urgent basis. I must say
It's
that
a bad time of the year to start trying to do this
bad
now.
time of the year. So obviously, if he could attend court, taking into consideration that recess is a few days away, maybe he could go to court early in the morning, of at least get a look at that file, digest it, and then seek advice early in the new year. I mean, 2-3 weeks in the bigger scheme of things will not
be okay.
throw the apple cart
But
over
don't just
completely.
leave it,
But
basically.
please don't leave it for 6 months or whatever. Make work of it in January as a matter of urgency.
What What is summer without your favorite song? The SABC brings you the #1 SABC summer song. And the best part is that you get to be the judge. For SAFM, SMS the letters SAFM, the name of the song and artist to 33175 to vote for your favorite SABC summer song. That's not all. By voting, you stand a chance to win a brand new Kia Picanto, plus a weekly cash prize of 5,000 Rand. You can SMS as many times as you like. Voting closes on the 30th of December 2016. SMS costs R1.50. T's and C's apply.
SABC Summer Song, powered by Kia.
No one lays down the law like car and key. This is the Law Report on SAFM.
Right, and we've got an email now from Sibongile. He's talking about a problem with a car that he bought, and it's a whole thing about picking up the car, or there was problems with the car, and he's taken it back, and there have been problems with the parts that they replaced it with. Discovered that actually the parts were not changed by himself. He'd been sold a car with faulty parts, apparently. And effectively, I mean, it's a very, very long email. I'm not going to go through the entire thing, but he just wants to know what he can do, because he says the car had accident damage. If he'd known that, he wouldn't have bought the car in the first place. And, you know, all the parts that came with it weren't, by all accounts, brand new parts. What can you do after the fact with something like this?
You know, it's really difficult, particularly when it comes to motor vehicles. We often advise clients that they need to have a few checks and balances in place when you are buying, particularly a second-hand motor vehicle. So, firstly, is you need to buy from a reputable dealer. Try and avoid sales between private individuals. Unless you go to an attorney, you make sure the paperwork is thoroughly checked, etc. You need to ensure that you get a roadworthiness report from the seller of the vehicle, and you need to ensure that you do a check on it to ensure that it's not a stolen vehicle.
Police clearance you need.
So there are a few documents that we actually recommend you obtain before exchanging any money.
But at all accounts, this was a car dealership. It wasn't a private
Yes,
person.
I note that, and that's even more shocking. So these dealerships should provide these reports for your inspection before you actually exchange any funds. And they usually also make you sign some documents. So we don't know what documents the listener has signed and what the contract, if any, provided for. So let's assume there was a document, there was a contract. Then hopefully I'm wrong and there isn't some fine print in there precluding the listener from taking any action or essentially buying it footsteps. Of course, if he asks certain questions regarding the vehicle, regarding the parts, whether they are genuine parts, whether there's an accident history, generally speaking, again, depending on how the contract's been drafted, he could use that to say, but this person told me that this was the case or that was the case, and it's not. It was a misrepresentation, in other words. Now, if the contract doesn't have one of these clauses in it to say that if it's not in the contract, it never happened, in simple terms, then that could be an argument that the listener could follow and say, listen, I want to cancel the contract. Here's your car. I want my money back. And let's go our separate ways. So then they could use the element of misrepresentation and say that there was never a contract between them, and therefore we need to exchange back so that we are in the position we were if this had never happened.
Would the Consumer Protection Act play any role here?
Again, the Consumer Protection Act is the second portion because it's a dealership. If it was a private person selling maybe an extra vehicle or a vehicle that they are replacing, then it's problematic because you're not doing it in your ordinary course of business, which is a requirement for the Consumer Protection Act to be applicable. So yes, the Consumer Protection Act is probably applicable, and then in that case it can be reported to the Consumer Commission, but it could take quite a long time. I believe the Commission is quite inundated at the moment with lots of complaints, and particularly motor vehicles seems to be a problem. If the dealership, so the listener could go the route of misrepresentation, get yourself an attorney and go through the courts, or consumer protection route, go to the commission, the ombud structure, or If the dealership is registered with one of these industry bodies, of the automotive industry bodies,
Right. But Industries Federation or something, I think it used to be called.
Yes.
I'm not sure if it's still that though.
RFI or one of those, then they've got an industry ombud that could also be approached. But it depends if these guys are registered and all of that. So I think the best way forward for the listener would be to maybe just book an appointment with an attorney. I see they are up north, so maybe it's a good idea to book a consultation with an attorney just to get some guidance
And
on
if
these
there is a
three
contract,
options.
just take it with you, if there is one.
Yes, take the contract with you, and take it forward from there. So then you can decide which is the most appropriate action. Obviously, if you just elect one of these and you go down it blindly, you may actually run out of time to exercise one of the other options. So it's best in this situation to actually seek some advice, even if it's just a consultation to point in the right direction and then to take the action.
So
from
all
there.
is not potentially lost. There is still
No.
possibly something that can be done
Definitely not.
here. Okay. Great. Then we have another one. It says, me and members of our community organisation were harassed and unlawfully arrested by the police for bringing up the strategy fair enough to help with the process of employing members of the community. We were trailed for 12 months with 2 different charges. We have successfully lodged a claim of unlawful arrest against the SAPS, but we also wish to lodge a civil claim against 2 other parties involved in the entrapment. And he says that it was a construction company and a municipality. What can he do? Please help.
Well, it would essentially also involve court action, obviously civil court action. So they provided that they are within the 3-year period, that prescription, there's no indication that
No,
it's
there's
more
no
than 3
dates
years.
or anything here, yeah.
So hopefully no prescription isn't applicable. So you'll just approach an attorney, set out on what basis you are claiming and the amount that you are claiming from these other 2 parties, and then proceed pretty much along the same lines. If you've been successful already against the SAPS,
Yes.
And some money has been paid, then it may not be possible to institute a further action because of the once and for all rules, something like double jeopardy, which the Americans have, that we have in South Africa. So you've got your you've got your opportunity once and for all.
But this is for 2 different people, though. I mean, so the one was against SAPS, and the other civil claim was 2 other parties, not the same.
Yeah, you can't profit from litigation. That's a fundamental rule of law.
So even
if, let's say, something has happened, it's usually related to the event, not the persons.
Okay.
So the event happens, damage is suffered. In this case, there's been arrest and multiple parties were involved in the unlawful causing of damage. So then usually you have to bring a suit against everyone involved once and for all, and then the court will decide, okay, this person is liable but maybe not that person, or all of you are liable, you must pay jointly and severally, so the person can choose who to recoup the damages from.
Okay.
But you can't launch an action and then launch another one. They could say that it's similar, it's a duplication, so if this party pays you and that party pays you, then you'll make a profit, you'll be paid twice. So
Okay.
that's essentially what they're trying to avoid.
So they need to go and just get some advice
I
here.
think get some advice. This is also, we don't have enough information to really say anything further than that.
Okay, right. And then I got an email here. This is actually quite unbelievable when you read through it. It's quite long. It's got copies of emails that were sent between the parties. But to put it in a nutshell, from Leslie, it says, it seems totally unreasonable and probably illegal for students who have studied for 2 years in good faith for a national diploma in early childhood development to have to wait more than a year for their qualification to be issued. It has still not been issued from 2015. I believe it prevents them artificially from proceeding with their chosen careers and must be against their constitutional rights. And she says, is this a case for the Human Rights Commission? And there's all this correspondence between herself and this place where these students were studying, and they just seem to be passing the buck here all the time. It's just it's not their fault, and it's somebody else, and something's happening, and you have to wait, and the process takes a while. But you can't expect people to wait over a year or 2 years, or however long it is now, for their qualifications, for heaven's sake.
Well, the most obvious answer to the question, and I think the most bulletproof of all of the potential options that may be available, is of course, to launch a High Court interdict application to compel them to issue the qualification, and obviously to add all the parties that are seemingly passing the buck between each other. That would be the most costly, of course, but maybe more than one person's been affected, then it can be a group of persons bringing the application, and it could then also.
Well, these are all the people are
cost.
basically students. I think Leslie's just speaking on their behalf. So they
Yes.
obviously, and they're not working, so there's no income basically.
No,
So
of
what
course.
is the thing that they could do that isn't going to literally put them in the hole financially for the rest of their lives, effectively?
Yeah. Well, hopefully, it wouldn't cost that much if it's spread over a multitude of people. But that's the first and best option. The other options would be, of course, to follow the internal complaints channels within the various departments of government that are involved, yeah? And quite frankly, I don't think that is going to give them the result, particularly not in the short space of time that they are seeking.
What about her suggestion of the Human Rights Commission?
The Human Rights Commission could be of assistance, but again, time frame wise, I'm not sure that this is going to give them a quick solution either. It could very well have an outcome for them, but it could also take 6 to 12 months further down the line.
Sure.
So as I'm saying, I really do think. And I know usually we give a couple of cost-effective options and court options. We don't just straight away jump into saying run to court. But in this instance, I really do believe that would be your only recourse to get a more reasonably timed solution.
Would this be something that you could actually get them to pay your
Yes,
costs?
of course. In many cases, like matters that are brought against the Department of Home Affairs, they've been in the forefront of litigation when it came to paperwork not being issued on time or timeously work permits overall. And then you'll often see the courts being approached to interdict them, to force them to issue a document or to make a decision on something. So it seems to be a very effective tool, and in most instances it's not always opposed, so it means it brings the costs down to a minimum.
And they could actually apply for costs as well.
Yes, and they would naturally apply for costs as well, particularly given the long time that this has taken, that it is also actually precluding them from obtaining employment.
Now, the one thing we just must mention, because I was actually quite surprised, I didn't realize that. I think I was talking to William Booth or somebody about costs, and they said you need to understand when you apply for costs, it doesn't mean you get everything back. Now, that's what I didn't realize. I thought if you applied for costs, you got what it cost you to launch this case, but that's not the case, apparently.
No, well, they say the matter of costs is not an exact science. To quote one of the cost consultants that we work with quite often when we draft bills for purposes of obtaining costs back once you've been successful in a matter. So it depends on the scale. We always ask, particularly in a case where there's been a deliberate delay or a deliberate malicious act which has caused the parties to end up where they are now. If you can prove that element of fault and malice, then you can often approach court on the basis of awarding the costs to the maximum scale. And when you achieve that, then you pretty much get everything back that you've spent. If it gets awarded to you on a lower scale, now the lower scales are the tariffs that are published in terms of the court rules. That is, in terms of market-related rates, about a third of market-related rates, between a third and 50% of what the market is actually charging out there, which means you've spent X amount and you get 50% if you're lucky. The other thing is, if you're using advocates, the more senior your advocate is and the more or less complex the matter is, the more likely it is you will not be able to recoup the costs of that advocate that you've used. So it's important that your attorney, when you are going to litigate, actually explains all of this to you. And for any listeners who are interested in the topic, we've got an interesting piece on our website that sets this out quite nicely, and that we've been using for many, many years to explain to our own clients, to say, if we are going to litigate, you need to go into this with open eyes. It's going to take X amount of your time. We're going to need Y amount of your inputs. So some of the things we can go along and take from you and relieve the pressure, but there are certain inputs that you will always be responsible for. And then, of course, when we go to the High Court, we need to brief an advocate. These are the risks that you run in terms of costs. We'll do our best to get you the maximum back, but you need to tally this and say, what is my threshold? What type of costs can I not exceed to continue being financially responsible?
So where would they find this rather scary information?
Well, it's on our website. I can send you the link if you want.
Okay, but if you want that link, just drop me a mail to law@safm.co.za. Just talk about the costs, and I will send you the link to Nicoline's. She'll send it to me.
Yes, well, otherwise, just go to www.skumanlaw.co.za, and there's a search bar, and you can just type in legal costs, and it'll pop the article up for you.
Okay, we're going to take some calls now. Take our first call on the line, Inot in Brits. Inot, good evening.
Hello, evening, ma'am.
How can we help you, Inot?
Yes. I had an accident in 2013. I was driving this truck, a certain company. I was involved in an accident with a BMW. It's a big truck, a Superlink. So I told them the accident. They said I must go and report to the police station. I reported. I gave them everything, the details of the guy I was involved with, and the details from the police station. So they told me that they are going to their lawyers, that company, they are going to take care of that case. So from 2013 until they terminated my contract in 2016, with other things, not with the accident in 2016. So when they terminated my contract in 2016, in August this year, in February, they terminated it in February. So the same year this year, in August, while I was waiting for another company, they sent me the summon of the same accident. So that summon, the summon came from the guy's lawyer. It was saying, that guy, the one I was involved with, he said there is a case between me, the company I was driving with, against him. So when I received that summon, I contacted that company I was working with. The company, the guy involved, the boss of that company, they said I must make an appointment so that I can go there and talk to him. When I went there, they said no, the boss is very busy, you can't speak to him. Till now, I am unable to speak to that previous boss I was working with. Now those people, that guy, they say I must pay for those damages of that car. So I just want to know, is it possible that I can pay while I was waiting for that company, because that company I was driving, the truck I was driving, is insured. They say their trucks are all insured.
That was I was about to ask you. I mean, surely they would have been insured. Why must he now pay for it?
No, definitely. The other thing that I just wanted to ask you before we get into the facts further is, when did the accident take place in 2013? You say you received the summons in February this year.
No. I received the summon in August this year.
August. Okay,
this
so
year, yes.
when in 2013 was the accident?
The accident was in October. It was in October 2013.
Oh, okay. Now, I'm just wanted to check the prescription, but of course they now made it just in time before it would have been prescribed in terms of the 3-year period. But okay, that's unfortunate, but so. Firstly, as an employer, particularly if you run a transport business, then you would have insurance on all your vehicles. And if any of those vehicles are in an accident, then the insurance would pay for it. So if there hasn't been a payment between the person suffering the damage and the insurance company, then it's something that your previous employer's insurance should just sort out.
Because it sounds like the BMW guy is now trying to sue him, but you can't really do that.
But you can't do that because it's even though he was the driver, he's not the owner of the vehicle concerned, and not the owner of the insurance, and so on and so on. So it's definitely it's important to go to court. I know the summons arrived already in August. That hopefully there hasn't been a judgment. If there has been, you need to get an attorney to overturn the judgment. Otherwise, they will, of course, execute it against your property of sorts. So it's in a nutshell, if your erstwhile employer wanted to keep you accountable for something, it would have been for the excess payment. And that would need to happen in terms of the labor law with proper notice and all these things. They can't all of a sudden claim the excess from you now at this point. That is definitely prescribed already. So
the other thing is, when I received those summons, I contacted my lawyer.
Yes.
So when I contacted my lawyer said I must send those papers to him.
Yes.
So I did send the papers to them.
Okay.
So when I send the papers, they say I must write a statement. So I wrote a statement. I send the statement to them. So they answered me. They said that my case is weak. They can't help me with this case. They are going to refer me to another lawyer. Then that other lawyer I'm going to pay from my own pocket. After all, I pay every month with this lawyer I have.
I'm sorry to hear that. No, I do think you need to seek different advice then of someone who is obviously willing and committed to.
Because that doesn't sound like a weak case to me. I'm not a lawyer.
No, it definitely doesn't. It's a valid point. If you're not the owner of the vehicle, you're not the owner of the insurance policy attached to the vehicle, it was a company vehicle that was driven, then the action cannot, in my view, lie between the driver unless there was gross negligence of some sorts. But, then, of course, they would have to make out that case and bring the link back. But still, it would be an action between the driver that suffered the damage and the company. And if the company feels that there was negligence, then they would have to.
But that would be the company then, not the other driver.
So to me, there seems to be a lot of discrepancies, and I think you need to approach an attorney and someone to look through this properly and to deal with this properly. I'm sorry you've had the poor experience with another attorney before this.
Yeah, but that doesn't sound right, Enoch. You need to go and speak to somebody who can help you.
Yes, and urgently. Don't delay it for too long.
All right.
All right. Thanks a lot.
All right.
Thanks a lot. Good night to you.
Good luck.
If you have any questions, you can call us on 0892 10 2010. 0892 10 2010.
The 8th edition of the Buyele Kaya Pan-African Music Festival returns to the Buffalo Cricket Stadium on 18 December 2016, featuring Dorothy Masuka, Jonas Gwangwa, Ringo, DJ Black Coffee, Sipogazi, aka Kanda Pongoman, The Soil, Msaki, Moby Dixon, Babes Wadumo, and many more. Get tickets at 200 Rand from CompuTicket, ShopRite and Checker stores. Cooler boxes 50 Rand each. Gates open at 10 a.m. No glass, no cans, no weapons, and no pass-outs. Buyele Kaya Music Festival, going back to our roots.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, so while we're waiting for some more calls, and you can call in on 0892 10 2010, don't leave it too late because then we won't be able to talk with you. But now we've come to the end of the year, and always with the New Year's resolutions, which no one ever keeps. But we should do the ones about the wills. We love talking about those.
I think 2016 has been a tough year for many of us. It's been a year of quite a few interesting happenings, and it's definitely something that we need to be very open about, and something that we need to really consider properly and do some reflection on. So for many of us, I think 2016 has been tough, and with tough comes lessons, and for many of us it's maybe been the best year yet. So be that as it may, maybe some reflection is good for this time of year to see from business perspective or personal perspective what worked, what didn't work, what worked better than it did last year, and keep on doing what worked, and to make provision for that in one's will and estate plan, particularly from a business perspective. I think if you've implemented some new measures in your business and things have been running more smoothly as a result, keep on doing that, and work towards the smoother processes, and then link that up to the wills. Similarly, those things that didn't work so well, maybe some reflection is needed on why not. I think it's a good time of year where we do these reflections, and maybe if we do that more intensively,
Yes.
then we'll have better New Year's resolutions at the end of the day. Asking the questions, the why, the how, the unpacking of the good and the bad. So I think it's really very necessary. And if you've started a family, I mean, that's my reality.
Yes.
Then definitely you need to make sure that your will now accommodates that, and accommodates the hopeful, unlikely event that you would pass before your child reaches the age of majority. And if that were to happen, to make sure that there's measures in place in terms of who would be raising them, who would be looking after them financially and emotionally, and all those aspects. So it becomes very much a legal consideration, but also a human consideration. Similarly with a business, if you own a business, it's like having started a family, in my view. Then you've got a responsibility, or you need to be accountable, and you need to make sure that you've put some measures in place as to what will happen, who will take over, who will make payments, what are going to happen to the employees if it happens, or must they just pack their little bags and no notice or anything like that. So there are quite a few things to consider, even if you don't have a family. If you have debt, you have to consider how are you going to put measures in place to pay for the debt? Do you have insurance in place to cater for that? So I do think, even though it's fairly gloomy, I suppose it is something one needs to really consider soberly.
The one thing I was I was happy with this was the Wills Week in September it was. And how many people actually emailed me afterwards to say, thank you so much for sending me the list of attorneys participating in their area, and how many of them had actually gone for the very first time to go and have a will done. And I thought, gosh, well, at least we're doing something right.
That's great. And,
Yeah.
and these opportunities are valuable. And unfortunately, Wills Week is over for 2016.
Well, it's coming again for 2017. So.
But if you can't wait until then, and I'm a little paranoid when it comes to wills. Rather, if you don't have anything in place, rather make work of it and get it sorted out. Particularly the festive season, we are all well aware of the fact that our roads become just that much more dangerous, and the risk of something really bad happening just becomes that much more over this period.
We're not trying to be gloomy about this. It's reality. Unfortunately.
So make sure that you've got your plans in place.
Right. And 2017, we will let you know when the Wills Week comes up, because we had a huge response last year. I was sending out lists of participating attorneys to everybody. And I'm so glad that so many people took us up on that. Well, not took us up on it, but took up the Law Society and their offering on that. But listened to us and took advantage of the fact that they were going to get their first will, basic will, I told everybody, for free.
Yeah,
which
that's
is
great.
So it was a great opportunity. Right. I think we have a caller on the line. Anne in Sea Point? No, not yet. We're still trying to get hold of her. Anne is around. We're just having a problem connecting the line. Right. So that's one of our New Year's resolutions. What else are we going to do for 2017? We can start planning it now, so it's not shock on the 1st of January. So get our business affairs in order, and our home affairs, which is our wills and estates and all that sort of thing, and just make sure that you've got everything. The one thing I always like to tell people is you need to put stuff in a place that everybody's going to find. If heaven forbid something happens to you, it's not going to be a treasure hunt looking for the paperwork.
Oh, yeah.
Or
surprises that come out of the paperwork,
yes.
like a lucky packet.
Yes, so you need to put all that together. What sort of things should we be putting there?
It really depends, I think, on your particular situation and trust issues, particularly from a family member's perspective. So if you have any concerns regarding trust, so in other words, if you think someone may abuse some of the information if they were to stumble on it, then maybe we should be a little more selective in what you put in it. If not, then it shouldn't be a problem. But generally, people put anything from a list of insurance policies that they hold, the policy numbers with the insurers, if they have multiple bank accounts, the bank account numbers, the bank names, And then some people go a little more in depth and list things like doctors or insurance brokers or key people that would have some information that is pertinent to the administration of the estate. And then lastly, some people actually do list passwords.
I was about to say, that's one of the things. I had a friend whose husband passed away. They couldn't get into his computer. They couldn't get into anything because they didn't know what the password was. They had to get someone to hack into the thing. It was ridiculous.
Yeah, from a cost perspective, it is ridiculous. But in any event, it is open to abuse. Let's be honest about it.
No, sure.
If you leave your internet banking PIN in your documents, then someone may actually clean out all the accounts, and they may. I've come across situations where the people doing that do it completely, almost want to say innocently, where they think, but I'll move the money, I'm the executor anyway, and I'll make sure that it is handled properly. And of course it doesn't look very good when you have to account for this. And sometimes, there are expenses and they think, okay, but I've got the money and, it is from the estate anyway, so I'll just pay this and I'll pay that, and it becomes a snowball. So rather not. Rather just leave it, even if you do have the password, would be my advice.
Okay.
And appoint an attorney to help you through the process.
Right, okay, very good advice. Well, we have a caller on the line, but before we go to that, we just need to hear this.
Afternoon Express is giving you the chance to win big. Tune in every Monday to Thursday live at 5 p.m. on SABC 3 and look out for the Advent Calendar logo on screen, which is your cue to call into the show live and stand a chance to win an awesome daily prize. By being a daily winner, you will also be entered into the grand prize competition where you can walk away with a brand new car. That's Afternoon Express, weekdays at 5 p.m. on SABC 3.
Express yourself.
No one lays down the law like Car and Key. This is the Law Report on SAFM.
Right, let's go back to the lines. Colin in East London, I think it is. Colin, good evening.
Good evening, thank you.
Hello.
I'm really appreciating this program, and I would like to, get some advice on the way forward with regard to my situation. It so happened that in 2013, I was driving between Alice and Middledrift, which is in the Eastern Cape. And ahead of me, there was a car which was more or less like it was actually indicating to the right. So I had to shift to the left so that, I could find my way. Unfortunately, in front of my car, there was, a number of goats which, this person was trying to usher to get them off the road. I happened to hit into that goat, and then my front part of the car was kind of damaged. And then when I stopped, this man came, and apparently he was a police officer. So when he talked to me, we kind of, quarreled, and then we went to the police station where I was breatharized. And then after breatharizing me, what he did was he took me to Alice Hospital, where my blood samples were taken, and then he took me back to Middledrift, where he locked me up for a night. The following day, I was released, and then, of course, I had to claim my insurance on my car. But however, I did not. When I put in the claim, what happened was the insurance company had to seek a police report, which they got, and then that police report, the person who wrote the report, the police officer, the traffic officer rather, indicated that I was smelling beer, and then the insurance indicated that they would repudiate the claim in the sense that I was driving under the influence of alcohol. However, they would wait for a final report with regard to, the medical findings, that is my blood results. A long time afterwards, because I had to go for, to get my firearm.
Colin, Colin, sorry, we've only got about 3 minutes left. So if you want to just get to the end of the story, quick.
Yes, I'll cut the story short. I received the report, from the police saying that we don't have, any evidence to prosecute you. And then, from the court also, the court said the police has no evidence to prosecute you. And, going forward, I now said, what about my claim? Because you wrote to the insurance that, I was found drunk. But however, the court has said that there is no evidence, to prosecute this matter. What is my way forward? Because, you see, I lost my money and I was not drunk, but that policeman just slapped me and, he locked me up.
Mm. Well, of course, there are two aspects here. One is the aspect of the insurance, which you can deal with through the insurance company's internal mechanism. So if they're still refusing the claim, then follow the internal processes.
Take the short-term ombud as well.
And if that fails,
Short-term
which it
insurance
probably
ombud.
would, then you need to go to the short-term insurance ombud, and they could then resolve it further, hopefully. And if that fails, you have no other choice than to bring a claim against the insurance company in court. So, but hopefully it doesn't get to that point. As for the police officer and the wrongful detention and all of that, you can bring a claim for wrongful arrest and detention and brutality if there has been any, a civil claim, and that unfortunately needs to go through court. It can't go through any alternative mechanisms. So those are the two courses of action that you could potentially
But you go through
take.
IPID for the police
Yes,
claim.
in fact, what has happened is that, I've attempted both. I went through the ombudsman, and then, they maintained that the claim should be repudiated by the fact that the traffic officer, the police officer who was there, just using his visual, he was able to tell whether I was drunk or not. That aside, but my contention is that, the breathalyzer which was used is that perhaps maybe it was 40. And then, the main, we should have been, the medical evidence, which is not available. And then, how come, the claim cannot be sustained?
Well, then, if you've already been through the ombud structure, then your next course of action is to seek the advice of an attorney and to take the matter to court. If you feel the ombudsman's recommendation was flawed. So essentially, you'll be appealing the decision. So I think get some advice from an attorney specializing in insurance law in your area, and get them to advise you on the best way forward. But you could potentially have recourse by taking the matter to court and essentially appealing the decision taken by the ombudsman.
Thank you for that. But however, may I ask, is it, in order to go before the public protector, can this case, be looked at
No,
by the
not
public?
really. No, it's not a matter of public interest really, unless of course you want to go the route of police brutality to the effect that it involves the behavior involves the entire department, not just one person. So for me, it needs to just purely based on a logical deduction. It needs to involve a group or a bigger public interest, not just a matter between two individuals. From what you are saying, it could potentially be.
Okay. So I must take this matter before an attorney so that
Yes.
it can be, be heard in the court of law.
But
Yes.
one who specializes in insurance law, Cullen.
Yes. Not just any attorney.
Because not all
someone-
attorneys, like a lot of them specialize in certain aspects of the law, and would possibly, this East London would fall under the Cape Law Society.
Yes, it should.
Yeah, so
yes.
possibly if Colin get hold of the Law Society of the Cape Town Law Society,
Yeah.
the Western Cape, basically, and they'd be able to ask them to recommend one of their members who deals in insurance law,
Okay.
and that might be the best thing. Do you have an email address, Colin?
Yes, I do.
I'm going to put you back to my producer and I'll give him your email address and I will send you the contact details of the Western Cape Law Society, and then you can get in touch with them.
I'll be very, very
All right. Good luck with that, Colin.
Thanks. And
Thanks.
it's quite a very profitable, program that you have.
Thank you very much. Enjoy the rest of your
And,
evening.
Wishing you all the best for the, next year, and all the best for this festive season.
And you too, Colin. Thank you so much for the call.
Thank you.
Thank you.
Thank you. Good night to you. Well, just apologies to those listeners we couldn't get on the show this evening. We've kind of run out of time, as we seem to do every week. Well, my thanks once again this evening to Nicoline Skuman-Low. She's the director of Skuman Law Inc., attorneys, conveyancers and notaries public, and their practice here in Cape Town. She's been my guest on tonight's edition of The Law Report. And we'll be doing another law clinic, wait for it, on Monday the 13th of February. I mean, that's just scary. Nicoline, thank you very much for joining us this evening.
Thank you so much, as always, for having me.
Well, in next week's programme, we're taking a look at proposed amendments to the trust legislation, getting some more information on the rights of a juristic person to engage in private prosecution, talking about emolument attachment orders, and getting some clarity on lawyers and attorneys. That's the Law Report next Monday, the 19th of December. And I'll be back with you again tomorrow evening just after 9 with Health Matters. It's our monthly phone-in, and I'll be joined by dermatologist Dr. Mohammed Dokrat, so join me for that. Stephen Kirk is up now with some nighttime music. Hello, Stephen.